morning.
Oh yay, oh yay, oh yay. Anyone having business before the Superior Court of Justice? Attend now and you shall be heard. The Honorable Justice Hennessy presiding. Long live the King. You may be seated. Unless in accordance with the Superior Court of Justice protocol on the use of electronic devices, these proceedings are not to be recorded. Thank you.
Very nice, thank you. Good morning, all.
Morning.
It's possible, oh, people have moved around. It's possible, Ms. Evans, that we did not mark the compendium as an exhibit, or did we? C1?
I think we decided that it was going to, I think we decided C2.
Yes, we did C and
No, C1.
we could call it C.1 and C.2. There was a discussion and you asked and it was addressed as C.2.
Got it.
Do you have it marked and labeled as C and then?
Okay, C and C. Okay, very good. Council, we need to deal with the upload order or the recording order. What's a good time to deal with that?
Perhaps after the lunch break. I understand Ms. McNamara for Canada just provided the court registrar with a copy of an amended order just to deal with a few kind of sundry administrative issues within it. So
Okay.
I expect we're in a position to request that you take that order out after lunch.
Okay, thank you. Thank you. Okay. If there's nothing else, then Ontario. Go ahead.
Thank you. Good morning, Your Honor. My name is Tamara Barkley. Along with my colleagues, we represent Ontario in this matter, and we're grateful to have an opportunity to provide the court with an overview of Ontario's positions in this case. I saw your clerk hand to you, Your Honor, a rather large binder. It contains at the beginning a hard copy of our opening statement that you may wish to follow along with. It follows with an index to the tabs, which are the documents referred to in the opening statement, and that I'll be taking you to today, or at least many of them I'll be taking to you today. Hard copies of this have been provided to each of my friends this morning, and electronic copies have been provided to the court reporter, to Your Honor, the clerk, and to the representatives who are attending virtually, parties who are attending virtually.
Thank you. So shall we mark it?
I think it would be appropriate to do that. I'm not sure if Your Honor wants to mark the whole binder as D, or if you wish to do D.1, to use Mr. Schachter's terminology for the first portion of it, the opening statement itself. I'm in your hands on that.
I like guidance. I mean, to me, because it's in a
It's in one.
it's in a binder, it
one
could be a
binder.
composite exhibit of, we can call it Ontario's opening and compendium.
That's fine.
Does that
That's
suit
fine.
you?
And certainly, I understand, although I've left it to other people on my team, that the electronic copies that have circulated are in one or are in two. They're in one electronic file as well. So that might make sense to just do it as D.
Okay, that's good then.
Okay.
Exhibit D, thank you.
Your Honor, I wish to begin with what Ontario sees as the issues in this case. And we've set out in our opening statement that the court will have to determine at least the following issues. I've broken it into two subcategories. First, in the main proceedings, we've identified 5. The first is whether Canada breached any duties or obligations in relation to the Robinson Superior Treaty. And if so, what were they?
Okay,
The second is, did Ontario breach any duties or obligations in relation to the treaty? And if so, what were they? Third, what is the proper model to use to calculate any past damages found to be owing? The next one is, what is the monetary value of any past damages owed? And then number 5, is it appropriate for this court to make any orders beyond orders for monetary relief? And if so, what are they? The second set of issues that we've set out here relate to the Crown allocation dispute. And that, of course, Your Honor, is exactly that. It's the dispute as between Canada and Ontario. It's not a dispute about the amount to be paid at all, but rather who pays it. And we've identified 3 issues there. The first is, what emanation of the Crown is responsible for direct payment of any increased annuities to the plaintiffs that this court may find owing? Second, were Ontario's obligations to Canada in connection with increased annuities fully and finally extinguished as a result of settlements and arbitral and court decisions made between 1870 and the early 1900s, 1908 to be specific? And finally, on the Crown allocation dispute, the third issue, if Ontario has any remaining financial obligation to Canada arising from increased annuity payments under the treaty, what's the monetary value of that obligation, including interest, having regard to sections 111 and 112 of the Constitution Act 1867, what I'll refer to as the Constitution, and what in the documents you'll often see referred to as the British North America Act 1867. I plan to start with Crown allocation. I'm going to spend a bit of time on it first, and I address it first because the dispute between Ontario and Canada and the fact of confederation and the implications of the Constitution, Ontario says, are central to the resolution of all of the remaining issues in this case. If I may provide a brief overview, it's Ontario's position that because of the scheme of the Constitution, it never had the legal responsibility to make annuity payments to the treaty beneficiaries.
so that is, of your 5 issues, that is the answer to the second.
Yes. Yes, it's in, if you're in my opening statement, Your Honor, it's paragraph 3, and in particular 3 and 2.
No, I was looking at paragraph 2 of your issues, the issues in the
excuse
main
me.
proceedings.
Yes,
So you say that because of the scheme of the Constitution, Ontario's position, it didn't have any legal response. It had no legal responsibility
in relation to the payment of
with respect to
treaties-
the annuities.
That's right. In relation to the payment of annuities, base or augmented, we do not.
And that is the answer to your second issue in the main proceeding.
That's correct, Your Honor.
Got it. Thank you.
So decades before Confederation in 1867, Ontario and Quebec existed as the United Province of Canada, what you'll hear me refer to as the UPC. And Your Honor, the historical evidence will show that at Confederation, the new Dominion government, what I'll refer to as Canada, what we think of as the federal government, it became the sole entity responsible for the discharge of the colonial provinces' debts and liabilities which were existing at the Union. And you'll hear evidence that these debts and liabilities included the payment of all annuities under this treaty before you that were owed to the plaintiffs, whether base or augmented. Canada essentially, they became the first port of call for satisfying the financial obligations of the former colonial governments. The evidence will also demonstrate that all accounts with Canada respecting the pre-Confederation debt of the UPC, including those in relation to the annuities that may be owing under the treaty, were finally settled in the early 1900s. And as Ontario pleads, that matter is res judicata as between Ontario and Canada. Ontario has pleaded that even in Canada's best case scenario, it only has a legal right of indemnification against Ontario pursuant to Section 112 of the Constitution for 5% simple interest on 52.77% of any amount that Canada should have paid earlier to the treaty annuitants as increased annuities.
And is the 52.77 the split between Ontario and Quebec?
That's
the
correct, Your
colonial
Honor.
provinces?
Want to touch briefly on the evidence about the historical and legal framework that you'll hear about. Because the process and the nature and the results of the negotiation for Confederation, and it was a negotiation, and the ultimate enactment of our Constitution are the overarching realities that inform the liability of the Crowns in this action. And when you hear the evidence, regard must be paid to the manner in which the founding members of Confederation addressed what they described as then Indian affairs. As you know, Section 91, sub 24 of the Constitution assigned to the federal government, assigned to Canada, Indian affairs. And in doing so, the federal government became the successor in Canada to the government that had made and administered the treaty. I'm at paragraph 9 of my statement, Your Honor.
Thank you.
You'll hear evidence that the transition of responsibility for Indian affairs to the new federal government was deliberate. It was consistent with British colonial practice, Indigenous expectations about who their treaty partner was, and John A. Macdonald's desire to open lands for settlement and to create a strong central government to develop and implement national policies. But while Section 91(24) is an important constitutional element to this case, so too are the many sections respecting the rather complicated financial scheme that framed Confederation. And of no less importance is the provision that you heard of yesterday, Section 142. It was an arbitration clause that was inserted into the Constitution, and it provided for the resolution of disputes that would arise from the complicated division of the UPC into the new provinces of Ontario and Quebec. And you'll hear that there was a series of legal proceedings and then appeals in this regard that would take place for some 40 years following Confederation. I want to turn to that scheme, that financial scheme. The evidence will show that limiting exposure for future contingent obligations was a major objective of each of the colonies who were contemplating Confederation. So at the time, that was the UPC, Nova Scotia, and New Brunswick. The framework agreed upon by the founding members to settle those individual colonial provinces' financial obligations, both existing prior to Confederation, prior to July the 1st, 1867, and afterwards, is a critical element of the Constitution. Ontario will address this background and the rather protracted financial negotiations through the evidence of historian Dr. Kenneth Coates. Dr. Coates' evidence will detail why, for the UPC in particular, the issue of public debt and its allocation between Canada and the soon-to-be new provinces of Ontario and Quebec was a great concern. Dr. Coates will provide you with his opinion that concern about government debt was a driving force in the UPC's push for Confederation. And he will explain, we anticipate that to enter the new Union of Confederation, Ontario and Quebec had to be confident that they would not be saddled with onerous fiscal responsibilities and liabilities going forward.
Is it problematic? Or am I getting too far into the weeds if I ask you what government debt was in Dr. Coates' opinion, was the driving force in the UPC's push for confederation? Which government?
It is a
The
bit
new government to be created?
It is a bit weedy. All of the colonies that were coming into Confederation had certain public debts. They had
Mhm.
assets and they had debts and they had liabilities. Dr. Coates, we anticipate, will describe to you the types of debts that those were and how they really drove the notion for Confederation and what the scheme would be in order to alleviate some of those liabilities for the provinces. And it will become a little bit more clear too, I think, as we go through those provisions of the Constitution.
So when you say government, you're saying existing and about to be created, that
Yes.
all government debt.
Yes, Your Honor.
Okay, thank you.
The financial scheme that was negotiated is actually set out in our Constitution itself. Sections 102, 108, 109, 110, 111, 112, 113, and 118 are particularly relevant to the Crown allocation dispute. At tab A, we've set out these provisions, Your Honor, and I'd like to take you through them briefly. Hoping that technology doesn't fail us and we can pull up tab A. And in particular, I'd like to pull up page 5 of our compendium. I think it should be showing on the screen in front of you as well, Your Honor.
Got it, thank you.
Now we see here, the top of the page, that this is part 8, Roman numeral 8, the Constitution, dealing with revenues, debts, assets, and taxation. We turn the page to page 6. The evidence will show, and in fact, you heard a little bit yesterday, that the financial scheme negotiated gave the provinces the land in which they entered Confederation. Section 109 provides that all lands, mines, minerals, and royalties belonging to the several provinces of Canada, the UPC, Nova Scotia and New Brunswick at the Union, and all sums then due and payable for the lands, mines, minerals, or royalties shall belong to the several provinces, subject to any trust existing in respect thereof, and to any interest other than that of the province in the same. We see that at section 110, also part of the financial scheme, certain assets related to the province's debts stayed with them as well. So they received those assets from the public debt. And then over the page, at page 7, I could take you, I point out section 118. Now you'll see there immediately that it's repealed. It was repealed only in 1950. If we go over the next page, Your Honor, page 8. And at 59, it refers to the footnote 59 at section 118 saying that it was repealed. This is the language of section 118 as it existed at Confederation.
Thank you.
And what's relevant here is that we see section 118, the following sums, the top there, shall be paid yearly by Canada to the several provinces for the support of their governments and legislatures. Ontario was to receive $80,000 a year. Quebec, the other portion of the UPC, 70, and we see numbers there for New Brunswick and Nova Scotia. And then under that bigger printing of those numbers, we see another small paragraph there, Your Honor. Section 118 went on to say that in addition, an annual grant in aid of each province shall be made talks about how many cents per person. And that shall be paid, and in the last 3 lines of that paragraph, shall be paid half yearly in advance to each province. But the government of Canada shall deduct from such grants as against any province all sums chargeable as interest on the public debt of that province in excess of the several amounts stipulated in this act. I'll come back to that concept in a minute because it's important. We go back though briefly to page 6. We see there that section 108, again, I'm still in the financial scheme negotiated and set out. Certain public works and property of each of the provinces, each colonial province entering confederation, enumerated in the 3rd schedule shall be the property of Canada. So certain things that the provinces had before 1867 are now Canada's. Schedule, the 3rd schedule is found at page 10. These are the sorts of things that I think most of us in this room would think of as falling under federal jurisdiction. There's things like lighthouses, harbors. Significantly, perhaps for this case, we see 6 railways and railway stocks, and then also 9 property transferred by the imperial government and known as ordnance property. I'd like to go to section 102 now. That's at page 5. We see here under the heading Creation of Consolidated Revenue Fund, section 102. And what this provision did is it gave to Canada the right of the province's revenues that they had been collecting up to Confederation for duties, revenues, taxes. It's essentially the provision of the Constitution that creates a direct taxation, one of the provisions that creates direct taxation for the federal government. And it goes on in the last few lines there. It says that these revenues shall form one consolidated revenue fund to be appropriated for the public service of Canada. So this was going to fund the new Dominion government initially. And the evidence will then show that in exchange, Canada became the sole entity for the debts and liabilities of the provinces entering the Union. We saw that yesterday with section 111. Perhaps we can go back to it now. It's at page 6. Ontario to be liable for provincial debts. Canada shall be liable for the debts and liabilities of each province existing at the Union. So again, we say that Confederation created new financial relationships where once the separate colonies stood as debtors, now Canada did. As I said earlier, they became the port of first call. Important though, to this case is section 112. Because while section 111 made Canada responsible for paying all financial obligations of the colonies which existed at the point of Confederation, section 112 on page 6 provided a right to Canada to seek indemnification. This provision relates only to the UPC, so now Ontario and Quebec, for interest on the amount by which the debt of the UPC exceeded $62.5 million. And that's the amount that's commonly referred to as the debt allowance.
And Ms. Evans said yesterday that by some mathematical calculation, if you keep paying the interest forever, at some point you've paid the principal. But that $60,000, was it always at $60,000? Did it ever diminish or did it ever, did it
You're
stay?
anticipating the rest of my statement, Your Honor. It's complicated. The 60.
It's like the rent to own thing.
Well, sort of. I think Your Honor said 60,000. That number 62.5 million gets increased. You'll hear me talk about that in a short while to that. But essentially, and as we saw in section 118, when Confederation happened, there was, I think Ms. Evans referred to it as an allowance that was given to a student going off to university. That's a nice analogy. I always sort of saw it as a line of credit that had been immediately completely tapped out.
Okay.
Because at the point of Confederation, all of that amount had been accounted for. So what was happening as new things were being found, or as the debts of the UPC were being divided and apportioned, they were being booked against the different accounts of those new provinces. So debt was starting to accrue. And as we saw in section 118, Canada was setting off those monies that it would pay for the aid and the funding of the provincial governments against the money that it was owed for that excess debt.
Oh, okay.
So I think I heard yesterday a comment that, you know, you would pay the interest and eventually it would pay it off. I think it's more accurate to say, and anybody I think who has a mortgage or a loan understands this perhaps, that paying interest alone never pays off the principal. You might eventually pay off the equivalent of what the principal started as, but you're not paying off the principal. You're just constantly paying interest. And in this case, we see in the evidence that in particular,
Only if interest continues to accrue.
yes.
But if the idea was, I don't know, if the idea was the fixed interest at the time, but yes, the mortgage example is helpful, that because the interest continues to accrue, all you're paying is the continuing accrual of interest.
That's right. That's right. And it was, and I'll take you to the decisions that provide for it. But the arbitral decisions and indeed an appeal to the Supreme Court determined that that 5% is simple interest. You heard me say that perhaps at the very beginning when I set out the issues. So that is something that helps a little bit, that some of us with mortgages don't have that advantage. It compounds rather than simple. But I will explain how these accounts, well, how they were accounted for eventually and how they were eventually, in fact, in the early 1900s, Ontario pleads that were wiped clean as between Ontario and Canada and indeed as between Ontario and Quebec, although that's not an issue you have to consider, obviously.
Okay.
I wanted to talk about this, this debt allowance and also the Consolidated Revenue Fund, though, because one of the important points in this case is that respecting the payment of annuities under the treaty, the evidence will demonstrate that at no time has that money come out of a fund set up through the net Crown resource revenues from the territory. The NCRRs, as I'll refer to them, as you'll hear me refer to them, they were an assessment tool as to whether or not an annuity could be increased. There wasn't a set aside pot of money for it to go to. And in fact, what actually happened, you'll hear evidence on, is that it's always been paid out of the CRF, the Consolidated Revenue Fund.
It being, you say it's always been paid out of.
Increased annuities.
Okay.
So, and in fact, even base annuities, because from 1850 to 1867, they were paid, annuities were paid out of the Consolidated Revenue Fund, the CRF of the UPC. And that, as I took you to, it included such monies as import duties and the excise taxes and tariffs that the UPC was collecting. And then since Confederation, the evidence will be that the monies necessary to pay the treaty annuities have been drawn exclusively from Canada's CRF, which was established by Section 102, in which those monies that once flowed to the UPC, in this case, but to the colonial provinces, are now flowing to Canada's CRF.
So you say, I can't remember what you said exactly. They weren't paid out of the NCRRs. There was no separate accounting for the NCRRs.
That's exactly, that's a distinction that I'm trying to make sure that we start off understanding that they're paid out of the CRF. Government pays out of the CRF. Now, you will hear evidence about decisions to capitalize the annuities as of Confederation. And the amount necessary to service the combined base amount for both the Robinson Superior Treaty and the Robinson Huron Treaty was determined to be $88,000. You'll recall from stage one, Your Honor, that those base amounts in dollar amounts, converting from pounds, were $2,000 approximately for the Superior Treaty and $2,400 for the Huron, you'll recall.
Mhm.
So that combined amount of $4,400, capitalizing it at 5% interest, was $88,000. And that's in the historical record. The historians will detail that to you. In May 1873, though, the UPC's debt allowance was increased. It was increased to approximately $73 million, bump of a little less than $10 million. While the statute was May 1873, it was made effective to the point of time of Confederation. So essentially, we would say that you can read out in 112 the 62.5 million and substitute the approximately 73 million. And that $88,000 then was sheltered under and included in the pre-Confederation debt or liabilities of the UPC. So in other words, the capitalization of those base annuities at that $88,000, they were not part of excess debt that was being paid through interest by the provinces. It was part of the debt allowance, the new amount of the debt allowance. So it's always been paid by Canada. It's Canada's sole responsibility under Section 111. I'd like to talk about the arbitrations that I alluded to under Section 142 and otherwise to divide the assets and debts of the UPC. And I think I said that recognizing that that was going to be a complicated affair and would take some time, the arbitration clause was inserted into the Constitution. And what it says is that there will be an arbitral panel of 3 members, that they're to be made up of a representative of Canada, Ontario, and Quebec, and that they have the exclusive jurisdiction to determine the division of the debts, liabilities, assets, and property of the former UPC. And you'll hear evidence. Thank you, Ms. Gagnon. My colleague has put up that language of Section 142 on the screen.
Thank you.
Should be at page 9 of our compendium behind tab A, Your Honor.
Got it.
I hope it's sidebarred for you.
It is. Thank you. Or no, it's not, but I can see it easily.
Thank you. You'll hear evidence, Your Honor, from our historians that the decision to insert this clause was crucial to Ontario and Quebec. And that's because it was imperative to them that the accounts and the assets of the UPC be divided. Having given up their main revenue that they had pre-Confederation, the new provinces became, at least initially, largely dependent on those Section 118 subsidies and grants that I took you to, but that against which Canada would exercise its right to indemnification and set off that interest. So until the UPC account was settled and divided, the amount that each of Ontario and Quebec knew that they would receive annually for their provincial expenditures was uncertain. And ultimately, there were 20 arbitral decisions rendered in order to address the division of the debts and liabilities of the UPC. The issue of the payment of any increased annuities promised in the treaty, including any arrears for interest, along with who the beneficiaries were the subject of several arbitral awards and indeed appeals to the Supreme Court of Canada and the Judicial Committee of the Privy Council. For simplicity, I'll refer to that as the JCPC. So too were the expenditures to be taken into account in ascertaining whether the Crown could augment without incurring loss. And these are precedents that have stood for more than a century. Historian Gwyneth Jones, on behalf of Ontario, will take you to the background of these decisions. We anticipate that the first arbitral decision of import is the one made on September 3, 1870. And that's the award Your Honor mentioned earlier. It addressed the relative responsibilities of Ontario and Quebec for the conjoint responsibilities of Section 112. And that arbitration determined that such responsibility was in effect to be split on the basis of 52.77% being attributable to Ontario and the remaining 0.23% being Quebec's responsibility. In an appeal to the Supreme Court of Canada from another arbitral decision related to the division of debts and assets, but unrelated to the Robinson treaties, the Supreme Court held that that award is as much a part of the Constitution as any other provision. Provided, I won't take you to it, but I provided the award and the relevant portions of the Supreme Court of Canada's decision at tabs B and C. They're sidebarred and they're referred to in my footnotes as well. In answer to written interrogatories that were posed by Ontario to Canada in September 2016 on this case, Canada provided the following answer, which Ontario intends to read into the record at the opening of its case. It's question 10. Please confirm that once responsibility for the excess liabilities of the province of Canada was divided as between Ontario and Quebec, the resulting ratio was not changed as a result of the subsequent identification, quantification of particular pre-Confederation liabilities. Canada confirmed that. And you'll hear that another issue that was decided more than a century ago was the question of what type of interest was applicable to pre-Confederation debt in excess of the debt allowance and when Canada could apply interest. We anticipate that Ms. Jones will describe to the court the background to what is known as award number 1. That was made November 2nd, 1893, Your Honor. It confirmed that when Canada sought indemnification under Section 112 against Ontario and Quebec, the permissible interest that could be charged to the respective accounts of the new provinces was 5% simple interest. Canada appealed parts of that decision. At tab E, I've provided the Supreme Court of Canada's decision. It upheld award number 1. It made it clear that Ontario did not owe interest on amounts that Canada had not yet paid to the First Nations. And if we could go to page 62. This was a 5-member panel of the Supreme Court of Canada. The Chief Justice spoke for the majority of the 4 members who formed the majority. And in the sidebar there, Chief Justice commented, interest is the price of the use of money or commodity. It cannot be due before its use has been enjoyed and for the duration of the enjoyment, though stipulated as a certain rate per annum, is never paid in advance without an express stipulation which is to be found nowhere in the British North America Act 1867. And these findings with respect to the type of interest, the simple interest, and when it may be charged are also pleaded by Ontario as matters res judicata as between the two crowns. And this is the crown allocation dispute. The court will also hear about arbitral awards and judicial appeals specific to the treaty, the Robinson Superior and Robinson Huron Treaty. One of these is award number 3. It considered who was liable for the increase of annuities to $4 per person. Canada, as you've heard, as you know, had augmented the annuities in 1875. They did so without prejudice to its position that it was not responsible for the increases to be paid or any arrears. Award number 3 in February 1895, the arbitrators considered the responsibility for increased annuities that may be owing both before Confederation and afterwards. I'd like to turn to that award. It's at tab F in our compendium. In particular, page 88. Paragraphs 4 and paragraph 6 are relevant. They break it down into pre-Confederation and post-Confederation. Paragraph 4 is respecting the years prior to Confederation. And the arbitrators found this, that any liability to pay the increased annuity in any year before the Union was a debt or liability which devolved upon Canada under the 111th section of the British North America Act 1867. They go on. This is one of the matters to be taken into account in ascertaining the excess of debt for which Ontario and Quebec are conjointly liable to Canada under the 112th section of this act, and that Ontario and Quebec have not, in respect of any such liability, been discharged by reason of the capitalization of the fixed annuities or because of anything in the Act of 1873. I'm going to pause there. The capitalization of the fixed annuities I referred to a short while ago, that was the $88,000 for the fixed based annuities. And the Act of 1873 was the Imperial Act of May 1873 that increased that debt allowance of $62.5 million to approximately $73 million. And what had happened here is that Canada and Quebec had argued that they were absolved of any responsibility because the debt allowance had been increased and the debts had been capitalized. And the arbitrator said, no, you're still on the hook for anything that's excess with increased annuities for pre-Confederation liabilities. Now they address post-Confederation in paragraph 6, and they say this: the ceded territory mentioned became the province of Ontario under the 109th section of the British North America Act 1867, subject to a trust to pay the increased annuities on the happening after the Union of the event on which such payment depended, and to the interest of the Indians therein to be so paid. That the ultimate burden of making provision for the payment of the increased annuities in question in such an event falls upon the province of Ontario, and that this burden has not been in any way affected or discharged. Record will demonstrate that Ontario appealed that finding. In particular, it appealed paragraph 6 and certain incidental paragraphs of award number 3 to the Supreme Court.
So just a little bit of housekeeping going forward. if you wish to give me authorities in this font,
It's awful,
I
isn't
will
it?
need, I will need some assistance.
Uh,
So you
understood.
Just use whatever technology you have available to you.
I believe that it is on the screen. I do apologize that the print version is extraordinarily small. I feel your pain. I feel your pain.
As long as
and-
it's shared.
Yes, and we will endeavor to do that going forward.
Thank you.
So before the Supreme Court of Canada, Quebec and Ontario argued what we understand Canada's argument to be today, which is that Section 109 should make Ontario solely responsible for annuities in the post-Confederation timeframe. But the Supreme Court of Canada disagreed. It allowed Ontario's appeal. And with what I hope is larger font this time, I'd wish to pull up tab G and go to page 108. Now, before the arbitrators and thus the Supreme Court of Canada was the issue of increased annuities. And in particular at the Supreme Court, the increased annuities to be paid for post-Confederation. And this is a decision again of the Supreme Court. It did split 5-3. The majority is again written by the Chief Justice Strong at the time. And he speaks of the 1870, the September 1870 award. And he notes that the Section 142 arbitrators tasked with dividing the conjoint responsibilities did not just decide the issue of base annuities, but also the increased ones. So if we look at page 108 of the compendium, he says, it is true that at the time this award of 1870 was made, no question had arisen regarding the payment of the augmented annuities. But this, in my opinion, can make no difference. There is nothing before us to show that the arbitrators of 1870 did not intend to refer to the liability to pay the increased annuities when they made their award. That liability was clearly within the terms of the 142nd section of the British North America Act and of the reference to them. And they had power to decide questions of law, as well as questions of account and matters of fact. And they were the sovereign judges of all such questions. It must therefore be intended that having before them the treaties and the act of parliament under which they acted, they decided as a question of law that the increased annuities were not charged upon the surrendered lands and that there was no trust of these lands for the purpose of paying the annuities. On page 109,
Is these last lines that you have just read me, are they the answer to what I heard yesterday, the 109 argument that the provinces took the lands subject to interests?
yes, Your Honor,
And you say this is the answer to that?
this, the decision of the Supreme Court ultimately, and also the JCPC affirming it, yes.
But these lines in particular answer that.
These lines in particular show, I think, Your Honor, that the arbitrators that were tasked specifically in the Constitution with the jurisdiction to divide this up said that 109 didn't apply to these annuities. They were clearly a Section 111 and 112 matter. We say for other reasons that Ontario has been released from any responsibilities to Canada for monies that may be owed, but that if you find against us ultimately in that matter, it can't be a 109 issue. The courts of the land have clearly said that it's not. And as much as there's feelings I heard expressed yesterday of unfairness, this is this is what the Supreme Court and the Judicial Committee of the Privy Council have said. The court ultimately concludes, Chief Justice Strong ultimately concludes at page 109 by saying this appeal must be allowed. The award must be varied by substituting for the 6th paragraph thereof the following. So that paragraph in award number 3, paragraph 6 that said 109 was applicable, Chief Justice Strong substitutes the language. It becomes the ceded territory mentioned became the property of Ontario under the 109th section of the British North America Act 1867, absolutely and free from any trust, charge, or lien in respect of any of the annuities, as well those presently payable as those deferred and agreed to be paid in augmentation of the original annuities upon the condition in the treaties mentioned. This is clearly referring there to the augmentation clause, and should it become applicable, this is all sheltered underneath it. It's not a 109 responsibility. As I said a moment ago, Your Honor, this decision was also affirmed unanimously by the JCPC the next year in 1896. We provided that decision, Lord Watson speaking for the JCPC at tab H. And it starts with a couple of words at the bottom of page 163. The majority of it is at page 164 of our compendium. He says, their lordships have had no difficulty in coming to the conclusion that no duty was imposed upon the province. I'm at page 13 of my statement and at page 164 of my compendium, Your Honor.
Got it. Thank you.
No duty was imposed upon the province, whether in the nature of a trust obligation or otherwise, to apply the revenue derived from the surrendered lands in payment of the annuities.
What's the year of the JCPC?
1896. It's a year after the Supreme Court of Canada's decision.
Thank you.
They will accordingly humbly advise Her Majesty that the judgment of the Supreme Court of Canada ought to be affirmed and both appeals dismissed. And it's our position, Your Honor, that the conclusion reached by the Supreme Court of Canada and affirmed by the JCPC is one of principle. It remains binding on Canada today.
And do you, I don't think Canada disagrees that with what you have set out exists. Canada argues that it is now nonsensical and inconsistent with other state succession opportunities. Do you intend to point to, as part of your opening, this is not your argument, as part of your opening in your roadmap, tell me how you will deal with that argument or evidence?
I mean, briefly, it will be argument at the end of the case, and we'll dealing with the evidence. But as I said at the beginning of my statement, Your Honor, Section 9124 made Canada the successor government in Canada. So the federal government, too many Canadas there, the federal government, the new Dominion, became in Canada the successor government to the government that made the treaties, the UPC on behalf of the Imperial Crown.
To the imperial government, all
Okay.
right?
So Section 9124 gave to, and deliberately so, gave to the federal government the responsibilities for treaties of that matter. They became, they're quite commonly known colloquially as the treaty paymaster. They administer the treaties. We don't agree, and we plead that we don't agree with the state successor. Do you understand that Canada believes that the 109 argument is nonsensical? I believe, Your Honor, that it was said to be so over 100 years ago, but disagreed with. And Ms. Jones, Your Honor, will further detail to the court that following these decisions that the post-Confederation annuity payments didn't come under 109, Canada brought back another claim before the arbitrators to determine exactly what it was, because I guess there was a sense that it was a little unclear. They needed a clear decision about what happened to them. So we have award number 10. And in that, Canada sought the determination that the contingent obligations to pay increased annuities under the treaty for post-Confederation time periods was a matter that was a Section 112 excess debt. And in that, the arbitrators agreed with Canada. So taken collectively then, award number 3, including the substitution of the Supreme Court of that language, and award number 10, what it stands for is that annuities are a 111 and 112 matter. Canada pays them directly to the extent, that any amounts owing are excess debt. Canada has a right of indemnification against Ontario and Quebec, subject to those other. And I want to turn to the decision in award number 10, and in particular, the reasons of Justice Burbidge. Go to tab I of my compendium, Your Honor, page 187 and 188. He's addressing again, they all address this 1870, September 3rd, 1870 award, the proportionment that guides them always. And he's talking about.
Is
Justice
this number
Burbidge-
10?
I beg your pardon, this is award number 10.
Thank you.
Yes, thank you. This is the one that following 109 doesn't apply. What do we do with post? So they decide what they're going to do with post here. And Justice Burbidge, in his reasons, he is discussing and referencing the September 3rd, 1870 award. And he's discussing as well the province of Quebec's argument as to what Ms. Glynis said was the unfairness. And he says this, should be sidebarred for Your Honor, we can make it big.
No, I've got it. Thank you.
It has been decided that Ontario takes the ceded territory free from any individual obligation to bear the burden, and that makes an end of that matter. The transaction is not isolated. Speaking here, you'll see in the rest of the reasons about Confederation, the transaction is not isolated. It forms part of a complicated arrangement, the terms of which the parties have themselves settled and which as a whole must be taken to be fair and equitable. If under the 112th section of the Act, the contingent liability of the Crown under the treaties in question is a matter to be taken into account in ascertaining the debt of the province of Canada, for which Ontario and Quebec are conjointly liable to Canada, then the award of September 3rd, 1870 has settled the proportions in which the two provinces are to bear that burden. Goes on, it seems to me that we should not depart from or attempt to alter the provisions of the Act or the terms of the award.
Thank you. Can I just ask one question on page 187,
Yes.
the second area that's sidebarred right at the bottom, and the sentence begins, and you read, but the transaction is not isolated. Which transaction are they talking about? Confederation?
The Confederation. They're talking about the different provisions, and they're talking about the negotiation of Confederation and the transaction. He refers to it as a transaction. Quebec appealed that decision. They appealed it to the Supreme Court of Canada in 1898. That decision is reproduced at tab J of our compendium. Supreme Court of Canada dismissed Quebec's appeal in its entirety. It's a very brief decision, Your Honor. It's at page 194 of tab J. It's from the bench by the Chief Justice. And essentially, he says that the arbitrators came to the proper conclusion. no further appeal was taken by Quebec to the JCPC. This decision of the Supreme Court is the highest on this issue. In the years following award number 10, there were 9 further arbitral decisions that moved Ontario, Quebec, and Canada closer to finalizing the UPC division and ultimately to closing out the former United Provinces accounts. You will hear evidence from Ms. Jones that at a meeting of the arbitrators in the second 1900 meeting for the unsettled accounts of Canada, Ontario, and Quebec, Canada's Arbitration Council, WD Hogg QC, confirmed that the governments of Ontario, Quebec, and Canada had reached a settlement agreement as between themselves, respecting the province's responsibilities to Canada, respecting in particular annuities that may be payable under both the Robinson Superior Treaty and the Robinson Huron Treaty. I'd like to take you now to the transcript, portion of the transcript of that meeting that addresses the Robinson Treaty. It's at tab K. The Chancellor begins, page 198. This meeting is called to dispose of one matter, but several others have been put on the paper. The first is the claim of the Dominion against the province of Canada upon the Robinson treaties. Mr. Hogg, again, Counsel for Canada, speaks. In the Indian treaty matter arising under the Robinson treaties, the several parties to this arbitration have now agreed that the amount to be charged to the province of Canada, UPC, under the respective treaties, and they've confirmed that by 3 orders in council, 1 from each of the governments interested. In addition to that, he goes on, I may say that they have also agreed as to a capitalized amount to be charged to the province of Canada account for all future annuities under the same treaties. He goes on, he says, so that it will be a final winding up of the Robinson Treaty case, not only for the past, but for the future. The amount to be charged, capitalized to be charged in the province of Canada account as of the 31st of December, 1892. The Chancellor asks if that completes the matter, and Mr. Hogg says yes.
So this is an articulation of the resolution arrived at amongst the 3. Is that
Yes,
correct?
as I see this, Your Honor, what happens is they come before, as we might think in a case management conference or chambers, and say that we've reached a settlement. He puts it before them and then ultimately awards sometime later, in fact, 2 months later, are issued by the arbitrators. I'm going to take you to them now.
And Ms. Evans referred to this as memorializing the settlement.
I don't
Is
believe that she was referring to this meeting. I don't think so. I think she was referring to award number 15 and the orders in council, but I stand to be corrected. I don't think it matters. I think we're all talking about the same thing.
Okay. So the Board of Arbitration, or I'm not sure how it's referred to, received or heard that there had been a resolution and that there were 3 orders in council
Yes,
to put it into
effect.
effect.
And at that same meeting, Mr. Hogg filed for final disposition and confirmation by the arbitrators, the Canada account containing all of the items still outstanding that had been in dispute between the several governments of Ontario, Quebec, and Canada, and which the arbitrators had also been charged with dealing with.
Can you just help me a little bit with the history then? So what we have is an appeal by Quebec, it goes to the Supreme Court of Canada, it's not further appealed. And then what is it before the arbitrators?
Well, so at that time, then what those decisions had determined was that increased annuities were to be a Section 111 and 112 matter.
Mhm.
So how that works, if I may, is that Canada pays them outright. And then because any increases would have been excess debt at a certain point above that new $73 million, it could come back to the provinces of Ontario and Quebec and seek indemnification.
Right.
And so this is still going on. This is still going on to the point earlier today, interest is being charged against these accounts, and monies that would flow otherwise to the provinces for those subsidies are changing, and they're not being paid out in full. So they're still there. And what happens in the next few years, it's about 4 years after that, 3 years after that final decision, making that both pre and post Confederation annuity amounts are a 111, 112 matter. The provinces in Canada come together and decide that they're going to capitalize this again. They decide, and the evidence will be, it's quite lengthy. Ms. Jones will take you through it, about agreement on pay lists, who's to be a beneficiary, who's to be included in that. And they decide
So
on these
sorry,
numbers.
so it's no different than what the decisions reflect.
No, the
It's just
settlement,
the details of it.
yes, the
Okay, and-
settlement is this, and then it's going to be formalized, if I may use that term, in the award.
Okay.
Okay. And then ultimately, as I said, awards are done, they're granted. They're signed August 1, 1900. Awards 15, 16, and 17 were issued to address the matters that Mr. Hogg spoke of at that June 2nd, 1900 meeting. And they're each relevant to the crown allocation dispute before the court. So as I said, I use the term, they formalized it. Ms. Jones will describe the history of that and what was happening in the background. But the settlement agreement reached by Canada, Ontario, and Quebec, respecting the province's responsibilities regarding annuities under both of those treaties. The amount that was determined was to be capitalized was $205,000, and that was to be charged to the UPC account. That's award number 15. Take you to it in a minute. The capitalization, to pause here though, the capitalization for $205,000, it differed from the $88,000 capitalization in a couple of significant ways. The first, of course, is that there's an agreement to formalize it. It's been papered, as we might say. It's been formalized in the arbitral award. And as noted by Mr. Hogg's address at the meeting of the arbitrators, orders in council, OICs, were passed by each of the three governments involved, one by each of Canada, Ontario, and Quebec. And then further, the record will demonstrate that each of those documents included clear language that in consideration of the $205,000, Ontario and Quebec were released by Canada from any further claims for indemnification respecting increased annuities under the treaty. I want to look at award 15 itself. I don't believe we looked at it yet. It's at tab L. Page 205. This is one of these really tiny prints.
Human frailties become visible.
Maybe we can blow it up a little bit on the screen. Thanks. So we see, first of all, it's the 15th award. top of the page, the 15th award on Indian, Huron, and Superior treaties. It's called the Final Award, and it's dated the 1st of August, 1900. We turn to page 207. We see clause 3 of the final award itself. I actually excerpted it in my opening statement. It may be easier to read.
Yes, I thought I saw it.
I'm at page 7.
14.
It's paragraph 49. I realize my page numbers I've been giving you may be a bit off.
I have paragraph 49. Thank you.
Paragraph 49. Award number 15 states, with respect to the said treaties referring to both of them, that there be entered and charged in the province of Canada account against the said province, UPC, as represented by the provinces of Ontario and Quebec, and as of the 31st of December, 1892, the sum of $205,000 in extinguishment forever thereafter of any claim by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaties. We would say that increased annuities under the said treaties represents any increased annuities. This would-
And do you distinguish between the term increased annuities and augmented annuities?
No, I do not.
And so there was a reference yesterday, and I'm just seeing if we've got all the same language. Is there any agreement with the language used by Canada about the difference between base and augmented annuities? Do you use that language in any of your
I think
references?
I think we both use the term base annuities and fixed annuities the same, which is the initial amount before augmentation,
Yes.
roughly the $60 in the Superior Treaty, and then the increased annuities is it was increased to $4. We call that the augmented annuities to $4 at certain times. But in this respect, we say that this release was dealing with any increased annuities that might be payable under the treaties.
So to the extent that might have been based on an interpretation that $4 was the maximum, so be it, you say. Whatever it was based on, it anticipated any increase.
It anticipated any increased annuities because it was based on the language of the treaty, which itself said that there was to be augmentation from time to time.
Okay.
We would say that as between Canada and Ontario, this certainly covers it off, Your Honor. This release language is picked up in the OICs.
Just to be clear then, increased to Ontario means any increase to the annuities that may come from the augmentation clause.
That is correct.
Okay. Thank you.
Ontario's order in council is actually reproduced as part of this award. It's at page 209 of the same tab, Your Honor. You see in the middle of the page, it says copy of an order from council approved by His Honor, the Lieutenant Governor, the 31st day of December, 1899. I also need my glasses, apparently. Over the page, at page 210, we see the operative language itself. We see that at paragraph 2, they refer to the cap $205,000 being charged the province of Canada account as of the 31st day of December, 1892. We see that it was be taken to extinguish forever thereafter the annual charge for and in respect of the annual claims on behalf of the said Indians for increased annuities under the said treaties. Goes on to say that the provinces of Ontario and Quebec as representing the late province of Canada are relieved from all liability and further payment in respect of the said increased annuities which may be payable under the said Huron and Superior treaties. And finally, clause 3, I'll just point out to you, references again that guiding source of apportionment, the award of 3rd September 1870. It says that this amount, the $205,000, is to be apportioned, divided, and transferred to the separate accounts of Ontario and Quebec based on the apportionment established in that award. We've also provided, Your Honor, with a copy of Canada's, the one that we had available through the archives of Canada's OIC. It's at tab M, it's handwritten. I apologize in advance for the copy. There is a transcript that came from the archives as well. It's at the back. You'll see it contains the same language. It's signed by the Prime Minister of the day, Wilfrid Laurier. And these full releases, Your Honor, and the
Just for the record, for sure, I can't read anything in tab M.
yes, but you may be able to at page, I can't either, at page 225 through 227. This is a transcription, I understand, of that handwriting that
Beautiful.
was not done by us. I hasten to add, this also came from the archives. Somebody with much better eyes than me managed to decipher it. Don't believe it's in dispute. Your Honor, I am aware of the time. I propose to go a little bit further and finish off this section about the awards, and then we could perhaps take a brief morning break.
Great.
So just to finish out about award 15, then it's Ontario's pleaded position that this release and this insurance of finality would have been a very important inclusion for Ontario and Quebec. And this is because, as you've heard me say earlier, in award number 3, the arbitrators had rejected Ontario's argument that that earlier capitalization and the increase to the debt allowance had discharged the provinces from any annuities that may be further owed. We rely on this and we plead that Canada is bound by its terms. Now, I referenced that award 16 and award 17 were also issued on August the 1st. And they were done in an effort to wind up, to take those steps to wind up the UPC account. Tab N, as in Nancy, is at, or tab N relates to award 16, page 230. See it, the title there, that this is the 16th award. And it's the account of the late province of Canada, so collectively with Quebec. Over on the next page, page 231. You go down to the last third of the page or so. There's sidebarring there. Award 16 references the other award of the same day, award, what we call award 15. It references the Robinson treaties and the balance that's to be apportioned. And it says it's to again be divided to the separate accounts of the provinces of Ontario and Quebec pursuant to the apportionment established by the award of the 3rd of September 1870. And then a little bit further down, it also says it sets Ontario's responsibility for the Robinson annuities at $112,350.53.
Is that on page 232?
It's on both, I believe. It's immediately after the section of on page 231 that I took you to,
Yes.
and it's also sidebarred at page 232. So that number, that $112,350.53, I'm going to come back to that. Award number 16 was made without prejudice, but it was made specifically without prejudice to any claim that Canada may have against Ontario and Quebec in respect of UPC debts or liabilities that were not yet then known and not yet then dealt with in the statement of account. Very clearly said in the part of the sidebar, at page 232. However, the statement of account clearly indicates the Robinson annuities. I'd like to take you to page 243 at that same tab.
Sorry, 243 or 242?
243.
Thank you.
So here we have the ending of the UPC statement of account
Mhm.
that has been filed before the arbitrators and forms part of Award 16. You'll see entries there at the bottom part of the page for 1892. And then in particular, that date, December 31, 1892. You'll see a number of references to the Huron and Superior Indian treaties. And ultimately, you'll see that included in the statement of account, that $205,000 capitalized amount that was to be booked to the UPC account. And here you're seeing that, in fact, that's been done. So to the extent that this claim or this award is without prejudice to any further claims that aren't included in the statement of account or that aren't yet known, it was known. It's in the statement of account. And finally, Ms. Jones on these awards will describe Award 17. That's at tab, where am I? That's at tab O, Your Honor. We look at page 247. We see this is the 17th award. We see that it's called the Account of the Province of Ontario. So it is essentially then taking all of that, which is in Award 16, which was all of the UPC, and it's now listing out what Ontario owes subject to that apportionment of September 3rd, 1870, that 52.77%, and it lists them. And it also noted that certain matters had not yet been finally concluded, and it's made without prejudice to the possible addition of those further things. It references in particular Treaty Number 3, the Common School Fund issues that went on for years. But it mentions that it's without prejudice to those things not yet included in the statement of account. Sure, you know where I'm going to now at page 263, Your Honor. We could turn that up. Go down to, again, December 31, 1892 entry. Maybe easier to read on the screen. We see an entry for December 31, 1892 to transfer from Province of Canada account the sum of $112,350.53. So that apportionment from the Robinson annuities dividing Ontario's proportion is listed in the statement of account. And finally, you'll hear Ms. Jones describe the various steps taken following this all the way up to about 1908 to finally and fully close out Ontario's account to Canada for amounts that were owed for excess debt. That relates to what Your Honor asked me about earlier. You know, what happened to these? Like, do they go on in perpetuity? In fact, they don't. There was set-offs done. I'll leave it to the historians to describe them to you. They are quite complicated. But ultimately, the account for Ontario was closed out. There are a few further defenses raised by Ontario in relation to the Crown allocation dispute that we wish to underscore. At page 58, Your Honor.
Mhm.
Ontario has,
Paragraph 58.
excuse me, yes, of course, paragraph 58.
Thank you.
Ontario has pled that all other issues aside, there can be no payment due to Canada under section 112 because Canada has never increased the payment to the annuitants over $4. So if there's money over $4 owing, there can't be indemnification for any amounts that have not yet been paid. As a matter of law, they cannot seek indemnification for either interest or principal relating it to further increased annuities. It's not been paid.
Well,
Further,
do you distinguish that from the minute it's paid or the minute it's ordered to be paid? That there can be a same moment in time order for indemnification? If there's an order
do-
against Canada.
we do, Your Honor, we say that the earliest that payment could be sought for indemnification, I deal with this as well, is that because they're unliquidated, they're not liquidated. As soon as we know what those amounts are,
Mhm.
that can trigger an indemnification, but it would trigger it from at the earliest, the date of Canada's cross claim against us.
So that's what I was asking.
I thought so.
Okay. You say could only be triggered
It could only be triggered at that point in time.
once it's liquidated.
Yes, it must be liquidated. And that's another matter that's res judicata as between us. That coincides with the decisions in award number 1 respecting interest and when it can be paid. The same principles we say apply to principal, same principles apply to principal amounts owing. And of course, that decision, as I took you to, was upheld by the Supreme Court of Canada when Canada could charge that interest at all and seek that indemnification.
Mhm.
And we also say that if any amounts are owing to Canada on account of principal, they're to be measured in the nominal dollar amounts. That is the face value of any dollars adjudged to amount to 52.77% of any share in any given year since 1851. We say that Ontario can have no responsibility for losses stemming from the time value of money. And the numbers that I've just described to you, they're generated in, the scenarios are set out in table 8 of our expert economist report, one of their 2 reports, the report titled The Value of the Augmentation Promise in the
Mhm.
Robinson Treaties. I'll call that going forward the Present Values Report. I've included tab 8. I don't intend to take you to it at this time. These numbers, of course, have been provided without admission of liability.
And when you say in paragraph 59, Ontario can have no responsibility for losses stemming from the time value of money,
Yes.
you are referring to what has been called the present value.
That's correct. Your Honor, unless you have questions about this, I might suggest that we take a short recess for the morning,
Okay,
and then I can turn to the liability and the main action.
all right, thank you. It's 15 minutes work, council. So I have 11:35.
Thank you.
Thank you.
This court will recess until 11:50. Thank you. This court is now resumed. You may be seated.
Your Honor, to orient you a little bit, I'm about 2/3 done, I think.
Thank you.
This morning, I covered off the province's position with respect to Crown allocation. I want to turn now to the liability in the main action. This begins at paragraph 62 and following of my oral statement. The evidence will show that Ontario neither breached any treaty obligation nor any duties arising out of the treaty. We reiterate Ontario's position that the obligation to pay treaty annuities and to exercise any discretion respecting increases entirely with Canada. It has remained with Canada since Confederation. The evidence will also show that the treaty beneficiaries regarded Canada as their treaty partner, and they persistently brought requests to increase payments to Canada's attention. It's Ontario's position similarly that any duties that it has in relation to the treaties arose solely from the honor of the Crown. As you know, Your Honor, that is a legal doctrine that has evolved substantially since the 1800s. The honor of the Crown requires the Crown to act with honor. It requires the Crown to act with integrity and good faith, in fairness, in all its dealings with Indigenous peoples. And in this case, we say that the duties arising from the honor of the Crown include the duty on the Crown, but here the federal Crown, to provide the treaty beneficiaries with sufficient information to evaluate the federal Crown's discretion and decision about how much to augment annuities. Ontario's duty to diligently implement the treaty supports Canada's direct duty to the plaintiffs. Supports Canada's direct duty to supply the plaintiffs with information. Ontario's duty consists of producing and supplying information to Canada concerning provincial Crown revenues and expenses in the treaty territory. Ontario has an obligation to do this when requested by Canada and commensurate with Ontario's ability to do so, given the various technological tools of the day, and to do so that Canada could exercise discretion regarding augmentation or increasing of the annuities.
Can we go back to the beginning of this paragraph? The duty, Ontario's duty, as you have it, is to support Canada's duty.
Yes.
Is it, are you, I'm just checking then that I've said it correctly. It is a duty to support.
To support Canada.
So when you say Ontario's duty to implement the treaty supports Canada, but it is a duty to support, and you say it's that support is to provide information as and when requested, subject to whatever the limits are on
Yes.
accounting. And you say you might be limited by technological tools, but is there any suggestion that you are self-limited by your own decisions on how to do the accounting?
No, I don't believe so, Your Honor. The technological tools reference will really be relevant as the historical record describes, and particularly through the evidence of Dr. Alexander von Gurnet, some of the attempts that were made to figure out things like what are the revenues, what are the boundaries, and not so much today, but certainly 170, 150 years ago. There's time lapse, and we say in many respects that some of those can be explained because people were working with different types of tools. We shouldn't be guided by GPS mapping that can happen today so easily, which didn't exist 170 years ago.
I'm not sure what you're saying. Are you saying that if someone asks for information in 2020,
Yes.
Ontario is limited in what it can provide?
No, I'm
You're-
saying,
Or you're saying that if someone asks for information in 2020, they should be limited to what could have been produced in, let's say, 1922.
I'm saying that when Canada requests information at any time about the revenues in the treaty territory from Ontario, which we acknowledge Ontario has that information, Ontario is to provide it to Canada. Ontario is to provide it to Canada so that it may then do its obligations under the treaty. And I'm simply saying, I don't mean for too much force to be put on it, but that certainly you're going to hear about delays in information passing. And we're just simply saying that back 170.
Sorry, when did those delays? That's what I'm talking about. When are those delays a problem? When do they
delays-
arise?
The delays are mostly a problem in the 1870s to
Oh.
1890s.
Okay,
And I'm
so
sa-
historical delays.
historical delays, Your Honor. And I'm just suggesting to you that when we think today about how quickly we can access information, that's not necessarily the case historically.
Okay, thank you.
Your Honor, you'll hear evidence that Canada's work of determining if the Robinson Superior Treaty Territory and the Robinson Huron Treaty Territory, because work was done on both of them, could support the $4 increase began in earnest in the mid-1870s. And it was prompted by correspondence from the Fort William First Nation to the Governor General of Canada. The court will hear also that Ontario did provide information. And again, it did so in the face of certain complications, in particular at that time about the Huron Treaty Territory and the borders of it. Ontario provided information while always standing firm that it was not the party responsible for funding or directly paying the annuities. And as you know from my statement this morning, Ontario's position on that was upheld by the Supreme Court in 1895 and then in 1896 by the JCPC. You'll also hear that when those accounts were finally set off, what I told you that Ms. Jones would take you through that rather complicated history. Ultimately, after 1908, Ontario held the belief that those accounts with Canada had been finally settled. And that forms the background, we say, against which the conduct of Ontario officials in supplying the revenue and expense information may be measured. And these sorts of matters, Your Honor, will be detailed in the evidence and the opinions of ethnohistorian Dr. Alexander Van Gurnet. I'd like to turn then to the value of the augmentation promise. This is the last section I wish to deal with this morning. Because with no admission of liability for payment, it is necessary for Ontario to address the value of the augmentation promise to the treaty beneficiaries. And the task that's been handed to all of us by the Court of Appeal has three components. I've listed them here at paragraph 75. The first is the calculation of net Crown resource revenues, that I'll refer to as NCRRs, in the treaty territory. The second task is determining the present value on those amounts. And finally, addressing the question of share. With respect to the NCRRs, the first component, Ontario approaches this through Robin Bodway and Michael Smart's expert report entitled Net Crown Resource-Based Revenues in the Robinson Huron and Robinson Superior Treaty Territories. I'm going to refer to that for simplicity as the nominal values report. You'll hear about how Professor Smart and Bodway believe that the public accounts of Ontario, these are audited financial records, are the most reliable source of historical, provincial, Crown resource revenues and expenses. And they rely on these records, these public accounts of Ontario, more than do the plaintiff's experts. One of the first things you'll hear from them is that they consider only net revenues that accrued to the Crown from the treaty territory to be relevant. They do this given Your Honor's stage 1 partial judgment and the Court of Appeal decision. Professors Smart and Bodway do not think that economic rents at large are relevant to the exercise that is now before the court, the same way that Professor Stiglitz and Mr. Hutchings for the plaintiffs do. The Stiglitz and Hutchings approach, including their applied interest rates, leads to vastly higher values than the already very large numbers elsewhere in the plaintiff's expert reports. And when it comes to the nominal value of Crown resource revenues, Your Honor, you'll hear that the evidence reveals very little meaningful disagreement among the various experts.
So that's what I thought after I had read them. And so I wondered about your statement here that your experts rely on the records more than the plaintiffs do,
Hmm.
or rely on them for different reasons, but no, isn't there a general acceptance of the nominal values?
Of the nominal value, but to get to the net value, we need to look at expenses. And that's where significant detail or significant differences do start to arise.
Yes,
So where they arise is in the area of applicable expenses that were incurred by the Crown in collecting, supporting, and regulating the revenues. And here, Professor Smart and Bodway, they'll tell Your Honor, they'll tell the court that in their opinion, the approach taken by the plaintiff's experts with respect to expenses is too narrow. In their opinion, the plaintiff's experts focus on expenses directly related to the collection of revenues without also paying adequate regard to those incurred to support or regulate the generation and collection of revenue. And they'll say to you that without the latter, the former cannot exist. The plaintiff's experts do not include several categories of expenses that Professor Smart and Bodway consider important and appropriate to include. Some examples include expenses relating to mining research, reforestation attempts, insect control of forests, forest fire management, surveys, land agents, and importantly as well, those in connection with colonization roads and railways, which of course the harvested resources could not be moved to market without. Your Honor, the evidence will show as well that in calculating NCRRs in the treaty territory, the plaintiff's expert, Mr. Hutchings, simply ignores data in the public accounts of Ontario after 1945. Instead, Mr. Hutchings substitutes a blanket 31.4% expense deduction from Crown resource revenues for the period 1945 to 2019 for all of the Robinson Superior Treaty area. Put another way, in all of those years, he always counts 68.6% of Crown resource revenues from the treaty area in his calculations, regardless of what the actual expenses were in the territory.
and your use of the word counts. What is counts? He uses that in his, all his other calculations.
He does.
Okay.
Ontario's experts will opine that Mr. Hutchings' approach disproportionately favors the plaintiffs, and it does so in two significant interrelated ways. First, Professor Smart and Bodway will opine that government expenses were actually high in comparison with revenues in the post-1945 years. Second, they will tell you that Mr. Hutchings' approach effectively reads the language without incurring loss out of the treaty for the years after 1945. You will hear evidence in fact that the NCRRs in the treaty territory have been negative since about 1960. I'd like to pull up tab Q of our compendium, Your Honor, and specifically page 268.
Got it?
This is table 11 from Professor Smart and Bodway's nominal values report. This demonstrates that the overall nominal values total of NCRRs in the treaty territory starts to consistently become negative in about 1960. That's halfway down the page under the column year.
I've got it. Thanks.
And then what Professors Smart and Bodway do to address the second component set out by the Court of Appeal is they tally these numbers in table 11, and then they bring them forward with interest to 2019 using Government of Canada long-term bond rates. They'll explain to you why, in their opinion, this rate of return produced by the long-term bond rates is appropriate, and it's the most reasonable multiplier to use. If we look at table 1 of their present value report, which is at tab R, here we see a summary of present value calculations. We have the amount of unadjusted NCRRs. That's the amount that if they had simply added up all of those numbers from the previous table, and it amounts to a total of negative approximately $7.89 billion. Then they risk adjust those numbers, and that's a complicated economic model that is best left for them to describe. But what it essentially does is that it ends up benefiting the plaintiffs because it takes those very high negative nominal numbers and it makes them much smaller. We see that the column under the RST and the row for risk-adjusted NCRRs drops down to approximately $19 million when they risk adjust it. And then what they do is they take these numbers and they apply their hypothetical augmented annuities model, which I'll talk about now. Because these amounts that they calculate use perfect hindsight and actual expenses and actual figures for revenues. But to assist the court in considering what the shared goals, expectations, and understandings at the time of the treaty would have been, Professor Smart and Bodway consider, again, from an economic perspective, the value that prudent persons would have reasonably placed on future NCRRs in 1850 at the time of treaty signing. And they call this the hypothetical bargaining approach. They estimate in that approach the risk-adjusted present value of NCRRs. Risk adjustment, they will tell you, is a tool of financial economics that's used to value resource properties and other assets based on the expected future incomes they generate and the risk associated with those incomes. In essence, what the experts do is consider the objective expectations of the parties by placing the actors on the ground in 1850 and asking what is a fair range of values that would have been acceptable to both the Anishinaabe and the Crown in exchange for the surrender of the lands. Professor Smart and Bodway will explain that this process engages a consideration by all sides of what the estimated value of the future stream of NCRRs would have been.
Is this an exercise completely within an economist's realm to place themselves in 1850 and opine on the expected future incomes?
As opposed,
Is it an economic exercise?
we think so, yes. We
Ah.
actually depart from Canada a little bit on the position that we heard yesterday. We do think that it's a mathematical exercise, not simply a percentages
Assessment.
game. It's something that can be and should be calculated mathematically.
And that when looking at expectations, economists, expert economists can do that. Expectations are assessed through an economic model.
They can in part. There is, of course, a role for Anishinaabe perspective. There's evidence to be led on that as well.
And does the Anishinaabe perspective, is that used by the economists?
They don't use it per se in this way. They're not experts in that field to be able to provide you with the opinion on that.
Right.
But they can look at, from an economic modeling perspective, what would have been objectively and reasonably contemplated for the lands. And they can run this math through and describe to you what ultimately nets out with what those numbers are. The model that they use, they call the Vidal-Anderson model.
I recall that.
You recall that? Yes. And what it does is that they take this.
I just say I had a hard time connecting the dots when I read it.
Okay. Better that they explain it to you than me, but let me try to hit some high points for you.
All right.
And that's with respect to when they consider the Court of Appeals' third component of share. They take these risk-adjusted values, and in their words, they run it through their hypothetical bargaining approach. And they perform that calculation as if the full amount of the risk-adjusted, so that smaller negative number, would be used to determine augmented annuities. And it represents, in their view, the maximum amount that the Crown, as a reasonable actor, would have expected to pay. The model that they propose for converting risk-adjusted NCRRs, what they call the Vidal-Anderson approach, it smooths it. So in the years that there's negatives, it's smooth so that it no longer is. It provides a steady and constant stream, and it doesn't allow it to drop below a certain unadjusted amount. So for instance, when you're looking at years in the past that have larger negative numbers, they're not impacted that way because of the smoothing of the values. They'll explain it to you in much more detail than I can. The Vidal-Anderson model, of course, you're familiar with it, Your Honor, or at least the term of those men's names, because it was a model principally based on findings of fact that Your Honor made in stage 1 and which the Court of Appeal did not alter. We're now supplement those findings with non-controversial historical facts, things such as the terms of reference that Robinson himself was given, and notes in his report on the treaty negotiations where he says that he relied heavily on the Vidal-Anderson approach. And ultimately, we anticipate that they will explain to the court why, in their opinion, this Vidal-Anderson model is is historically principled and it's sensitive to both risk and volatility in a way that other models are not. We anticipate as well that their evidence will be that assuming liability, the value of the amounts due for past annuities, net of amounts already paid to the plaintiffs, is in the order of $34 million. I'd like to pull up the table 1 again at tab R. You see here, this is what we looked at earlier. The hypothetical augmented annuities amount is positive. It's $336,940,954. And then the present value of the annuities already paid. So all of the annuities paid to date is approximately, is valued, the present value of it is approximately 300 million. That's the amount still, or that's actually been paid. And then the difference, the amount that is hypothetically due, is 34.7 million. Professors Smart and Bodway will also respond to the opinions of the plaintiff's experts on why total economic rents from resources is not the appropriate metric for valuing the augmentation promise. They will explain as well why the investment portfolio approach of the plaintiff's expert is flawed and it could never be implemented. And finally, they'll also respond to the opinion as to what are the comparative standards of living and how they impact the notion of sharing. Your Honor will also hear from Cliff Hamal. Mr. Hamal is an expert in respect of the energy sector, and he will speak to you with respect to Crown resource revenues arising from the generation of electricity from hydro facilities. Mr. Hamal also responds to the economic rents theory presented by the plaintiff's experts, and he identifies serious flaws with same in respect to their approach in the hydroelectric industry. Lastly, Your Honor, Dr. Eric Angel will provide evidence to you. Dr. Angel is an expert in the history and the mechanics of band trust accounts. He will trace the history of band trust accounts, and in doing so, Dr. Angel will explain the control that the federal government had over First Nations money. And Dr. Angel will further explain the uses to which band trust accounts were put in order to assist the court as to how band trust account rates might factor into this case, and in particularly respecting the plaintiff's 60-40 stock portfolio argument.
Which is essentially the difference between 5.4 and 7.2 in interest rates. Is it
There's a
5.4
lot
or
of numbers
5.3?
flying around the other day. I think that's right. I'd like to move to some concluding remarks then, Your Honor. Ontario's position is that there is a critical need in this case to separate the treaty obligations and other duties of the two emanations of the Crown. It's our position that they are not now, nor were they ever the same. The Constitution, the historical record, and the jurisprudence will demonstrate that at all times since Confederation, Canada alone had the treaty obligation with respect to the payment of annuities and the sole discretion to determine whether and when they should be increased or augmented. The evidence will show, we say, that Ontario's duties in relation to the treaty fell entirely under the purview of the honor of the Crown, and they were related to the supply of information to Canada. In the terms of quantum of any damages that may be owed, Ontario's position that the calculations of the plaintiff's experts are excessive, stretch into the tens of billions and on some of their models in excess of $100 billion. Ontario's position that the very large amounts advocated for by the plaintiffs would not have been in the contemplation of the treaty signatories, since they would create disproportionate wealth between the different communities in the same territory. And that this, Your Honor, would be contrary to this court's stage 1 decision respecting the common intention of the parties to share and provide for Indigenous and non-Indigenous communities, and also the directive from the Court of Appeal that sharing under the augmentation clause be based on the relative wealth and the needs of both communities. Your Honor, unless you have any questions, that concludes my statements for this morning.
Thank you very much. Okay.
I suppose before we break, just one sundry matter. This morning, Mr. Albanati brought to the courtroom and distributed to counsel in attendance here, as well as a copy to the court of the joint documents. So I thank you very much to Mr. Albanati and whomever else assisted him for taking that task on. It was no small feat.
While we don't normally give a round of applause, we do give hearty thanks for this huge undertaking and your stick-to-itiveness on it. Thank you very much.
So in any event, I just ask that that be marked as Exhibit 1.
Exhibit 1. Does anyone have a problem with it? I'm being handed a hard drive of the joint book of documents. And I take it this is joint of the plaintiffs, the interveners, and Ontario and Canada.
Yes.
Thank you very much.
I have one additional matter, really by way of question of procedure, I think. Often there's an order to exclude witnesses
Yes.
from a hearing. In this case, I understand from just seeing on my computer that some of the experts have been watching, and that's fine, but we're getting to a point in the evidence, for example, Stiglitz and Hutchings are provided joint reports, Bodway and Smart provided joint reports, and there's other joint reports. But I understand that witnesses are going to be coming up one by one, not jointly. And if we are going to be excluding witnesses who are going to be testifying, I'm not sure what my friends think is the appropriate procedure, but if we are going to be sort of saying, I'll use Professor Stiglitz and Professor Hutchings just as an example to make my, or express my concern. If Professor Stiglitz goes up and covers areas A to B and B to C, and then he can be cross-examined on that, but when Professor Hutchings takes the stand, he might cover areas E, F, and G, but since he's a co-author, are we going to allow him to be cross-examined on A, B, and C as well?
Is there a difference between those two questions? Exclusion of witnesses and what can be covered in the second cross-examination?
Yeah, I think there are
Okay.
two separate questions, but
All
I just want everyone to play by the same rules, whatever they are, and
Okay.
since I'm going to be leading off with the witnesses on Friday, I want to know that.
Well, let
Tell
me
my-
take a crack at question number 1.
Yeah,
And this matter is being live streamed and it's out there for the world to see. So I think it would be very difficult to consider an order for exclusion of witnesses. I might be wrong. That's just my first crack at it. With respect to whether there can be double cross-examination, this was raised, was it not? And was there any, did you have any opportunity to discuss this? Or did you
I
Did-
don't believe it's been resolved.
What, did you have different views? Is that why it hasn't been resolved? Like, just,
I-
you can let me know if this is a matter of dispute as amongst you, or it's just an open-ended question.
I thought how we had agreed to proceed in case management was to identify to the best of our abilities prior to an expert testifying the areas that they were going to be testifying to. To sort of draw a line as best we could between issues that respective experts were going to be testifying to. Now, it might make some sense to have the discussion with respect to this issue offline with our all counsel, and we could report to the court on Friday morning how we've landed on this sort of issue of, as Mr. Schachter's raised, of double cross-examination or asking the same question to two different experts. But with respect to the first question, perhaps my friends have some guidance or preference on the idea or proposal of excluding witnesses or asking them not to Zoom in or participate in any way until after they've testified.
Where are we on this?
Where we are, I think, is that we need to talk offline about this. I know this has been raised in a CMC by me some time ago.
Mhm.
I mean, you're right, it's live streamed, it's difficult, it's a different kind of animal in that sense. It's very
Mhm.
difficult to. And they've all certified that they're going to independently assist the court. So I hope, one would hope that that would cover off any issues arising from hearing evidence. I mean, that is the bottom line to it all. They have a duty to you. But let's have a little chat about it. The cross-examination point. I mean, off the top, to me, I would say if a report is and I'm quite happy to be convinced otherwise by my friend, but if a report is jointly authored, you can cross-examine either person on any part of it.
Even if you have cross-examined earlier.
Sure. I mean, would be really difficult in a practical way to not cross that line. I think it's just a kind of a fluid thing.
Okay.
So one guy addresses A, the second guy says, I'm not going to address A. I still think you can ask the second guy about A.
Mhm.
But I mean, the second guy will have heard what the first guy said about A too, the way things are lay of the land right now, right? So yeah, this is no big deal. We can sort this out.
All right. Do you need me to help you?
Not at this point. Perhaps we'll have that discussion amongst council and be prepared to speak to it on Friday morning.
Okay. And, oh, go ahead.
Sorry. Were we leaving this subject or are we going?
I'm taking Ms. Lewis's line to say, it looks like you can solve this amongst yourselves.
Yeah, we'll try and solve it amongst ourselves and report to the court on Friday morning or
Okay.
earlier. If we can get a joint email that we all approve of to advise the court. And finally, I will be circulating an amended appendix A-1 or whatever we called it, probably later today.
Okay.
Or I
So.
should say updated, not amended.
Updated. So, do we need to meet to discuss the uploading of the live streaming, or have you all seen the, and maybe the registrar can hand me the latest version of the proposed order? Does it come to me with your joint
From our
consent?
perspective, we're happy for it to be taken out. I don't know if that's the case from all.
I think
other
it came from
parties.
Canada originally, might be changed how you identify people, and Ontario or your consent.
All the parties have. previously- Right, that's fine.
Thank you. Are you content?
There is an additional version to the what's in your hand. that will print off the sense.
An additional a different version?
That just came in post the break that we just had.
Yes.
It just makes changes to how it'll be titled.
Oh, the title of the
the
document.
title of how it'll be saved on YouTube.
Okay, and can somebody, whoever did that change, can you advise the court? Then so we can have it on the record.
Here's the mechanic to the order at paragraph 1, which states the recordings and YouTube postings shall be limited to the court proceedings alone, to be titled on YouTube in a way to include the case name, event, day, date, and event.
So it would read White Sand and Red Rock versus AGC et al. Day, number, date, and topic description. So name of witness. All right. And throughout this order, the reference to the registrar is the court registrar, Ms. Pelkey, who sits before us today. Maybe a different person from time to time. So her job is to record while the live streaming is going on, which we all understood was happening. And secondly, to upload now to a YouTube, is it called a channel? The YouTube something channel, called or titled as in paragraph 1 of the annex.
Exactly, and I have provided
All right. Aren't we fancy? Okay, so I will, when this is in my hand, the last version, I will sign it and send it over to the court to take out, and I will ask Madam Registrar therefore to upload days 1, 2, and 3. And then from then on, at the end of the day or the next day, however it works, to upload each day subsequently. We have made great progress. All right, thank you. So thank you all for your openings. I understand we will not sit tomorrow. We will start Friday at 10 a.m. with the first witness, Professor Stiglitz. And with respect to room setup, are you content or have, I can tell you it's dark up here. So we might try and solve that, but somebody might do a bit of a tech run by sitting in the witness box and seeing if someone has to read documents or something, that it's available. Okay, I don't mind participating in that. But is there anything else that we see or have experienced in the last 3 days that should be modified in any way once we have witnesses?
When we do examinations.
Yeah.
I mean, what I'm gonna do, what I'm gonna do what you tell me to do, but what I propose to do, no surprise, is use a binder and, you know, put certain things to the witness, and everyone will have the binder, and we can mark the paper in the binder as the exhibits. We weren't sure if we were gonna land an electronic book, you know, we were kind of coming down to the wire, so we're preparing sort of to approach it as an old school paper trial, and you can just flip the tabs and hammer the exhibit you know, thing on the paper. But while we're doing that, I hope to be able to get the document up electronically too. And I'm made to understand that you can't get the there's some wish to see the time of day or something. So that means we have to have this view with 3 components. I would prefer if we could get up just one screen that just showed like a paragraph in somebody's report or
Well,
something.
didn't we have that when I was looking at
I know.
your documents just now?
Yeah,
in Ms.
so we can do
Barclay's?
that. Like, we're not required to be locked into this.
Do it,
3
I would say do it exactly as you did with the
Okay, as long as that's
opening
okay, because
documents.
I was discussing this earlier, and I thought that there's some need to do it this way in order to get some of the micro data. So I mean, what do I know? But Okay, easy, that's easy.
But I do have this to say, I'm hoping that the documents you're going to put to any witness in a cross-examination, do they come from the joint book of documents?
Well, they should be in there, you know, I mean,
Okay.
the idea is not to surprise anybody.
No, but if they come from there,
We should be able to have a number and pop them.
we don't need to mark them as exhibits. You might mark your compendium as an exhibit.
We can, we can
Is
just.
that is the whole plan to avoid the marking of all those individual, unless if my understanding from how we did it rather smoothly in stage one was the only new exhibits were exhibits that didn't already exist, documents that didn't already exist in stage one. So if you put together your paper compendium of however many documents you're going to be putting to the witness, that could be marked as an exhibit.
For identification, I guess, and we'll refer to the JBD number, and then you'll be able to follow the
That's right.
transcript.
And also at some point, well, yeah, I don't think you would need to, we can identify it by its joint book of documents number, but for working with it through the examination with the witness, I'm very happy that you give me a paper copy.
That just makes it easier. And I
So
mean,
exactly the
yeah.
way it was handled in the openings is I hope the way we can continue
Okay.
in the examination.
Good. Thank you.
Super. We deal with all generations here. Anything else? Okay, then I don't think we need to meet again on this order, so we will connect again Friday morning, 10 a.m. Thank you.
Oyez, oyez, oyez. The sittings of this court are now concluded. Long live the king.